I'm Mitchell R. Miller at EstatePlanningForYou.com. I've been a tax, trust, and estate lawyer for 30 years. I've started this website to help you get ready to meet with your own estate planning attorney. One of the things we want to do in estate planning is make sure that our client's estate does not go through probate. Why? Because probate takes time, costs money, and generates major aggravation. If you only have a will, your estate will go through probate. Why is this bad? Let me give you an example. My own mother's estate. She lived in Philadelphia. I live in Los Angeles. Correctly, she chose a Pennsylvania attorney to do her estate planning for her. Like many attorneys, he said, "Oh, probate is no big deal in Pennsylvania." Well, let me tell you, probate is a big deal in Pennsylvania or anywhere else. It took me 2 years to get my mother's estate through the probate process. If I had, only because I hadn't charged a fee, did those 2 years not take a big bite out of her estate. And there was untold aggravation, filling out of forms, and other time-consuming efforts. Here's another example. One from the May 2008 American Bar Association Journal. An attorney in Illinois said, "Probate in Illinois is relatively painless, so long as there is no litigation associated with it. Probate requires only 2 court appearances, and the decision-making does not require court approval, so long as there is no litigation or upset heirs interfering with the administration of the estate." Well, take it from me, there can be totally unexpected upset heirs or litigation that interferes with the administration of a estate. And even paying an attorney's fees for just 2 court appearances and required filings can cost your heirs a great deal of money. In some states, like California, probate fees are set by law. In California, a small estate of $500,000, and with California house prices, that is a small estate, will have to pay an attorney's fee of $13,000. And if the executor does not waive his or her fee, another $13,000. That's right, $26,000 in fees for an estate which might consist only of a small home. Plus, court filing fees, probate referees' fees, certified copied fees, and aggravation, too much to mention. Another problem with probate is that it is a public process. Your will is in the courthouse records. That means anybody can go down and read it. If there's a contentious relative who you want to leave out of your will, or if you just value your privacy, you want to avoid probate. What's the bottom line so that your estate doesn't have to go through these legal obstacles? A will is not enough to avoid probate. You need a living trust. A living trust has the same instructions for the disposition of your property that you would have in a will. But since the trust is a pre-existing legal entity, it continues after your death. Therefore, your estate does not have to go through probate, since there are no assets subject to your instructions which have to be proved. The successor trustees you have selected take over, carrying out your instructions. You still need a will in case certain assets are not transferred to the trust. For example, if you walk out of your lawyer's office and get hit by a truck, your lawsuit against the trucking company for wrongful death is not in your trust, and therefore you have to have a will to pour that into the trust. That's why we call such a will a pour-over will. In the coming weeks, I'll be providing you with information you need to plan before meeting with your own estate attorney. When you have an understanding of the estate planning ramifications before you meet with your own attorney, you'll save time and money. Thanks for listening.